Uh, Hi, sir. So basically, the students joining in today with us are from the engineering background. I mean, they're still in college and they're finishing up their engineering. So all these students, they have started on an idea, a startup idea, and they have created prototypes for their business or the idea that they have. And right now they are on the stage of creating their startup. I mean, they're converting their products into a business. So basically they're going from idea to business. And so these students, these teams, they have some of them have registered their companies, some of them have are in the process of registering their companies, and further they're just looking for some guidance to what patenting is and why is it important and so on and so forth. So that is a background on the students. And I think we have 7 students with us. Let's just wait 2 more minutes and then we can start with the workshop. So, teams, I would request you to please switch on your camera so that we can see you and you can also see us.
Hello.
So it's 4:10. Let's start the workshop and more students will keep joining. Is that okay with you, sir? So you're on mute.
Hello everyone.
Hello.
Everyone
Can I
is
just
there?
uh,
Ishita, Dipanshu, Shivansh. Are
Hello.
you all
Hello, sir.
people? Yeah, hi.
Hello, sir.
Why don't you show your faces also? Young faces. It's good to see you people.
So, students, let me just give you a small brief of Dr. Madhuranjan Vats that we have here. He is a distinguished academician and professional with over 15 years of impactful contribution across industries, educational institutions, and startups. He is a PhD holder in green marketing and certified World Intellectual Property Organization expert. He has been guiding force for researchers and innovators worldwide. As a thought leader in innovation and intellectual property, he brings wealth of knowledge, experience, making him a sought after mentor, advisor, and speaker for everyone here. So, sir, I invite you to start the workshop. Welcome, sir.
Thank you, Janvi. Thank you. So what I want you for you all people to, if at all you people can show your faces, it would be easier for me to interact with you all people, right? So I just wish that you people have your cameras on. It is, thank you, Gaurav. Thank you. Okay. Shivans, Dipanshu, Karan. Nishita, see, this is very new field of IPR is basically very new field, right? You had been studying multiple subjects across. When you passed your 10th, you had the idea of all the subjects, physics, chemistry, math, civics, SST, everything that you studied, right? But this is something new. That's why I wanted it to know bit more interactive with you all people, so that it should not be like I'm just speaking and you people are simply listening, right? I wanted that when I'm speaking, I'm asking some questions also, and so that I understand that what all you are understanding about what I'm speaking about. Um, and that is why I wanted that you all people should show your faces. It shows me that okay, you people are actually taking some idea about it. Thank you, Sivansh. Thank you. Okay. Uh, you all have been into this startup kind of thing, and I'm actually attached with a number of startups uh, whom I'm guiding, whom I'm uh, mentoring basically with regard to their intellectual property. No, as a matter of fact, it is the intellectual property of yours. Hi, Harsh. Okay, so it is actually your intellectual property uh, that actually led you to start something new. Means this startup is basically the resultant of your intellectual property. It means you don't have bought something from somewhere. You have not traded it, means you have not bought it from outside or from anywhere, and now you are selling it. It was something in your mind, and that you basically finally that you created, and that is actually getting sold into the market, right? So basically it is that product of your mind that we will be calling it intellectual property. Now this intellectual property that we are going to see right now. So before we go ahead, I would just like to have some questions from your side, that any of wild questions that you have with regard to this IPR or with regard to patent, copyright, trademark, any of these things, please let me know. Accordingly, I will start my PPT, and then one by one I will try to define and make you understand everything also. Yeah, please, anyone.
Hello, hi
Any
sir.
wild questions that you might be having?
Hi sir, hi.
Hi, Harsh.
Hello. Shivan sir, Shivan this side.
All right, Shivans, please tell me.
Yes. Sir, actually I wanted to know when I was searching for some similar patents on the
Hmm.
site, there was a list of many patents, but not the exact, but yeah, like it contains it like when I entered the keyword, so it showed me many patents for that keyword, containing that keyword. So is there any specific way to find what we want to find for targeted, uh, like if you want to target something and find that, is there any specific way to find that?
Okay, good question. Right, Shivans, in patents, what we call actually the patents is definitely there is it is in itself a subject, right? It is a subject of law, and in law it is like in engineering also. You have read um, for the whole 3 or 4 years, then you learn something and you are now able to do something. So accordingly in this IPR also, patent searching in itself is a different zone. uh, to be very specific that exactly your patent is there in the market. In general, that you search, there is a free available data, and on free available data that is actually Google data, there the free things are there. So you found some of the things and you might not have found a lot of things. So it is getting searched through multiple pet data also. It is worldwide searching thing, and then there we find the patents, right? It is great that you have that kind of understanding. So for that, you need to approach some of the experts of this IPR who are basically doing this searching work, and then they will help you in that case, right? Well, so from this understanding, I believe that you have some idea of patent, but still, I will have to thank you, Sivan. Okay, so please, इसको open करो, PPT को open करो. I will just be giving you some brief about this patent and how patents are not the copyright, and how patents are different from trademark, and all these differences among the IPR domain. So this is me, Madhuranjan Vats, and then you go down. Yeah, okay. So here I'm just, this is my disclaimer that I would like to, whatever I'm going to state here is just for the benefit of you people, and it is just for the educational thing, and nothing, it is not nothing like I'm selling anything here, right? So this is just a disclaimer. Okay. Now, this is what I'm going to discuss now. But and all IPR that we have here is actually relating to the IP laws of India, right? Uh, have you heard about the copyright? You all have heard? Yes?
Yes, sir. Yes, sir.
Right, right. So copyright, accordingly, patent. So all these things, copyright, patents, designs, trademarks, GI, semiconductor integrated circuits layout, protection of plant varieties, all these are basically part of IPR, and all these are governed by a law, and all these laws being enacted in different time frame, like Copyright Act got enacted in 1957, and then Patent Act got enacted in 1970. Means from that time onwards we have our own law, and that law guides us that what is patentable, what is not patentable. Everything related to patent is coming after that time. So accordingly, Designs Act is coming in 2000. Then Trademarks Act is getting regulated by 1999 Act, GI, and all these things. And all these things are going to be very important for you people. Right. So introduction of intellectual property here I have taken as your first slide to make you understand. It actually covers a vast range of activities, and it is basically divided into two main categories, right? So industrial property, and this is the first category, and the second category is copyright and related rights. Industrial property is actually about the patents and the industrial designs and the trademarks and the GI. This is the first category. So in industrial property, whatever is relating to the industry is actually patents, industrial design, trademarks, and the GI. However, the second part, that is also actually IPR, when that is covering this literary part, artistic part, scientific works, or the performances, all these things covered. So broadly, if you talk about IPR, it is into two parts: patents, industrial, and the second part is the copyright. And next is, this is a very important thing that you need to understand, that if someone is inventing something, he is known as inventor, but will he be called as the owner? Means it is important for you people, because you people have invented something, and when you file a patent, how are you filing? Means you are filing as an inventor, or you are filing as an patentee, or you are filing as an applicant, how are you filing? That defines that whether you are going to be the owner or you are going to have some share only. So this is important part that I want you to understand this. Can anyone tell me something about it? Means, is every inventor the owner of the invention or not?
Sir, I don't think so that every inventor is owner of the patent. Like, in two different countries, there can be similar products, but the patent, like the one who have already had the patent first hand, so he's going to earn over the like जो भी वो सेल कर रहे हैं दूसरे सेम डिजाइन को. So yeah, it is.
अच्छा, तीन चीजें आपने अभी कह दी. And all these three things, means all things that you are stating here is actually, it is like having, it is coming from different set. See, there is a term
Yes,
called
sir.
inventor. Inventor and owner of the invention are two different things that I want you to understand. This is a matter of fact. It is not a matter of country. It is a matter of fact about that if someone is an inventor of any product, he is not mandatorily the owner, as you stated correctly. But then you bringing the idea of this country and that country, uh, that is a totally different thing. So please don't bring that idea. Means country and all those things will come later on. Right now we are just talking about when we are assuming someone as an inventor, he is not mandatorily the patentee or he is not mandatorily the owner of that patent. So this is a matter of fact. As a matter of fact, we have to understand that inventor is someone different and patentee is someone different. Inventor is a person who has invented it. And when we file the form for you people, yes, you can also file on your own, but we as an entitled person from the government of India, when we are filing on your behalf, we take this precaution that because we understand that what it means as an inventor, what are the rights of what are your rights, and as patentee also what are your rights. So it is, I believe now that you are okay and you have understood this idea that inventor is not exactly patentee, right?
Yes, sir. Yes, sir. Yes, sir.
Right. And so who is patentee? Patentee is a person, he is the actual owner. How will he become the owner? When he is the applicant in the while he is applying the patent, he is the applicant, and then he is the by default owner first, right? But if he's just mentioning there that he's an inventor and he is not actually claiming himself to be the applicant of that invention, he will not by default be called as the patentee. So we have, when you are going for this uh, filing of the application, it is important that you mention it there that I want to become the owner. So accordingly, either you or your team who is actually representing you in the IPR segment, they will take care of this, and accordingly things. So means, yeah, just 2 days back, I have with me one person. He's also the startup person, and in the beginning, he was having. There were some people, so they started working, and they are doing quite good. Now they are in UAE, and he just came to meet me, and they were saying that one fellow of that team is not functioning properly. So what needs to be done? But in the beginning, actually, they were not knowing. So in the beginning, usually see what happens. People used to think that everything will be done by them only, right? So they did in the same way as in general people used to do. And there they forgot to mention that what rights will be with whom, and accordingly now they are facing the issues. But anyway, means we have accordingly we have decided what to be done, and that is happening. So what, who is the owner? needs to be defined. And that's why we think that it is important for you people to understand that by default, the inventor does not become the patentee. Okay. So by what method you invent, you already have invented. So I'm not exactly perhaps the best person to state, but still I have some guess because of the person whom I have met. I can state that even still, if you have invented something for the first time, again you have to keep inventing, because one patent is not going to give you the monopoly over all the business. So what you can do is that again you have to set a goal and set an idea, and you have to visualize it, that I have to do something with regard to this. I have to get more things, more ideas. So just note it down and then get a pre-patent search done by some expert. um, by that time you will be having some fund also with you, so you can get some pre-patent search report from those people. They will guide you with that, because that in itself is a specialized thing. They will do it for a month, for 10 days, for 15 days, and then they will come up with different related ideas, that here we have some nobility and left, means you can look for this idea. And then when you get this, then start working on it. And because it is between your team and you, and it's always confidential, don't forget, don't tell anyone. Means anyone. Any person who is other than you is anyone. Top very good friend, even husband, wife, brother, sister, if anything like that, means it is beyond uh, discussion. So please don't go for that, right? Now, intellectual property actually refers to the creation of mind. And the creation of mind can be invention, it can be designs, it can be literary or artistic works, it can be symbols, names, images. Because you people have started working, or you are about to start working in terms of company, so you need to be very choosy about choosing any of the things. Like when you are adopting any symbol, you are adopting any names, images, which you are going to use in days to come. Like you are writing anything about, you're copying from somewhere, and for the description of your products, you are choosing any of the designs also. All these things that you are choosing or you are adopting, you need to be uh, very serious about those adoptions, because right now you might not be falling in the bad hands, but once you will have some setup ready with you, and you will be having the money, and by that time you will come into the you will be known better than others. You will not be just the individuals. So there, if you have done anything wrong at this stage, it will be harmful for you in days to come. So you have to take care of these things, right? So what exactly happens if you have something that is quite noble with you, with regard to the previous slide I have mentioned? So there, if you are taking the intellectual property rights through the law, if you are taking it, so that will be beneficial for you. So there, what exactly happens? Like when you say design, it is about just design, nothing else. When you say noble invention, you get the patent. You do not get design for the patents. So design in itself is a different thing. Similarly, copyright you have to take also. When you describe your product and you put it there in the market, you take the copyright, because that is your expression for that product. All these things are very important. Even the trademarks are also very important, because when you adopt any name for your business, and if it is similar to others, it will be, how will you differentiate yourself from others? So differentiate yourself from others, you need to adopt some unique name, and ultimately that will be a brand, right? And then that will fetch you. Means right now, the Haldiram, the name itself it's very expensive, right? If you go into the market and to want to sell something, means that Haldiram, when they went into the market to sell the Haldiram, what exactly are they selling? It's just the name that they are selling. You have to understand this. And it is multiple billion dollars people were offering for this Haldiram brand. So that is why I'm stating that even when you are choosing any of the name, please be very specific. Always bring in some professionals so that they suggest you something better, and when you get it, you start investing in your company's name symbol, because ultimately that matters. The names that you choose, actually that becomes the brand in the days to come. Any of the name you listen is actually a brand, and brand used to have some value. So that you have to understand. Now, a problem can be solved through using product, apparatus, composition, tool, process, method, machine, device. This is for your products. Like what I have heard, that you people have got some product with you and you have some prototype also. So it is, in this case, it is mandatory for you people to go for the patent. In case if you are not going for the patent, see, market is full of people who are there to copy the things, and they, once you will invest a lot of amount and a lot of energy for your product, for your marketing and for everything. Now people will see the first product, and next day it will be filled with the similar sort of products, right? So it is important that if at all someone is having some product, apparatus, composition, tool, process, method, machine, or device, in that case they must get this idea of product or prototype, they must get it protected through the patent law. It is compulsory. Similarly, if you have that product, no, product falls into two parts. Means the second aspect of that product is that you have some unique design of that product also, that also need to be protected, because others can copy that design. So the design also need to be protected. Similarly, you have you got your startup, so your name of that company that I just told you, that needs to get protected. I believe it is it is sounding logical to you people, right? Anyone?
Yes, sir.
Yeah,
Yes, sir.
yeah. So, so right now we talked about three things in terms of your product that you already have, then the design of that product, and then your company. So you have registered a company. Registration of company is not going to save you in the market from your competitors, right? They can copy your product, they can copy your company name also, and you will not be able to save your any of the things until you have the IPR protection. So just filing company name or company is not going to make meaningful for you, right? Now, some thing relating to the copyright, I would like to make you understand that what comes under the copyright. Now, when any of the problems is when it is getting solved through any of the creativity, particularly literary creativity, artistic work, or expression in recorded forms, then it comes under the copyright, right? If you have written any novels, poems, and plays and reference works, or any newspaper articles, it comes into the copyright. Then if you have written the computer programs for or any databases for your product, then it needs to be protected through the copyright thing. Then similarly, like films, artistic works like paintings, drawings, photographs, sculpture, architecture, advertisements, all these things comes under the copyright. So if at all your any of the things is falling under this part, you need to take the copyright protection for your noble things. Now, a bit more about this patent, like I just had been listening, wherein people were mixing the things, like they were talking about design also, and they were talking about the product also. So when we are talking about patent, it's actually about the product, and product or the apparatus, composition or tool. Means there are a lot of things written here. Any of the things like product, apparatus, composition, tool, process, method, machine, device, any of the thing, when we are coming across this thing, now it comes under patent. It is there is a design related to the product, but it is not patent. Design in itself is a separate thing, and that is getting covered under Design Act, not under the Patent Act. So when you talk about patent in itself is exclusive, right? Means when it is given to you, it is just for you and not, for none other else person. And for an invention, there is only one exclusive right, and for a limited time frame. Means there is a 20 years time for which you are getting this, and this 20 years is getting counted from the date of filing. From when you file your application, from that date the counting starts. Not just the date, it is time, like uh, 16th November 10.10 a.m. So this much accuracy is there as time. So date or time start gets counted from this time, whatever is your application filing time. So in other words, a patent is an exclusive right of your product or any of the apparatus or composition that offers a new technical solution to a problem that you have solved. Actually, you all have, as much I know about you people, you all have resolved some of the questions that was existing somewhere, and you solved by creating either a product or a apparatus or a composition or a tool or a process or a method or machine or a device. All these things in itself means something, and all these falls under the patent. Is it clear? See, this is workshop, this is not class. So that's why
Yes, sir.
you need to be, if at all you have some question, please interrupt me, because that will be better for me also to understand. I hope patent is clear, right?
Yes, sir. Yes, sir.
Yes, exactly. Patent is about the product. It is not, it is totally different from all other things. Like when you talk about trademark, and when you talk about protecting any of the logo, any of the names. So protecting logos and names, many of the times I have come across these things. People used to get confused between trademark and patent. They call it the same. Means when they say that है ना, मुझे अपने कंपनी का ना पेटेंट कराना है, कंपनी का पेटेंट नहीं हो सकता सर, कंपनी के नाम का तो ट्रेडमार्क हो सकता है। तो मेरे डिजाइन का कॉपीराइट हो सकता है, मेरे डिजाइन का प्रोटेक्शन आपको अगर लेना है तो आपको कॉपीराइट एक्ट में लेना पड़ेगा। आपके प्रोडक्ट का पेटेंट होता है, सो दैट यू नीड टू अंडरस्टैंड। Okay, thank you. So now there are things that we have to understand, that what exactly is the invention. Because when you go for patent, it is actually the invention that is getting protected. Now people, not you, because you have already developed something, but a lot of people said मेरे दिमाग में कुछ है, उसका क्या करें, वो पेटेंट होगा क्या? अब वो until you express, no one knows about it. So it is very difficult to say that इसका पेटेंट होगा, कि इसका कॉपीराइट होगा, कि इसका डिजाइन होगा, क्या होगा पता नहीं, ये जीआई में जा रहा है, कहाँ जा रहा है पता नहीं. So if something is there inside the mind, there is no meaning. Invention is only when it is coming out. So either it is coming out in the form in which form it is coming, so that will define कि ये patent होगा या फिर copyright, it is going to be whatever. So When we talk about invention, it is actually a new product or process which is having an inventive step and capable of industrial application. See, there are three things here important for all of you to understand. When you give something to me, what I am looking for and how do I get patent for the people for whom I'm actually serving. I look for something noble. Is it new? See, if at all it is new, then rest of the things we have so far in last 15 years, we have understood that how to get the protection done, how to get the certification done. That we have, in the last so many years, we have understood. So it should be a new product. It is most essential thing, right? So if you are sure that it is a new product or a new process, then 50% work is done. Now you are about to get your certificate. The only thing is that you have to file it, right? The next thing, however, what is being looked after when people, the examiner, the patent controller used to look into is the inventive step and whether it is having the capability of industrial application or not. In fact, all the products that is coming into existence that used to have the inventive step and that used to have the industrial applicability also. So only thing that we actually look for is the nobleness. If it is nobility is there, then almost in 99.9% cases we are getting done. Okay. And now everyone is clear about this idea. Means there are three things I'm talking about: the nobility, first thing; the second thing is the inventive step, and the third thing is the industrial application. Are you all clear about this idea?
Sir, I have one question.
Yeah, please.
सर जैसे मार्केट में कंपटीशन तो भी होता है अगर
Hmm.
सिमिलर प्रोडक्ट्स के बीच में तो फिर वो कैसे हैंडल होता है पेटेंट से लाइक जैसे मेरे पास जो प्रोडक्ट है सिमिलर प्रोडक्ट ऑलरेडी अगर एग्जिस्ट कर रहा है बट मैं उससे बेटर या फिर चीप रेट्स में सेल कर रहा हूँ तो फिर हम उसको कैसे हैंडल करेंगे
अगर ये आपका है, ये प्रोडक्ट अगर आपका है और आपको पेटेंट मिल रखा है, तो कोई दूसरा उसको तो नहीं ला सकता। पॉइंट वन, वो सस्ते में ला रहा है कि महंगे में ला रहा है, वो मुमकिन नहीं है कि वो उस चीज को ला सकता है। अगर वो लाता है तो हम उसके अगेंस्ट में कोर्ट जाएंगे और हमें उसमें हमारे तरफ फैसला होगा, दैट इज फॉर श्योर। फिर आप किस चीज की बात कर रहे हैं? क्योंकि वो तो आपका है, फिर दूसरा कोई वही चीज नहीं ला सकता। फिर वो कब ला सकता है? वो 20 साल कम से कम उसको वेट करना पड़ेगा।
ओके
वो टेन्योर जो है, उस टेन्योर में वो आपके प्रोडक्ट को नहीं ला सकता है क्योंकि वो आपका प्रोडक्ट है। उसको तो आपका एक्सक्लूसिव राइट आपको गवर्नमेंट ने दिया है। इंडिया में आपने फाइल किया है तो इंडियन गवर्नमेंट ने आपको एक्सक्लूसिव राइट दे दिया। So now there is no probability of anyone to enter into this. I am already dealing with a number of cases also. And today I have sent notices to 2 people wherein एक आप देखते हो कि अभी एक प्रोडक्ट है जो इन्वायरमेंट क्लीनिंग के लिए वो वाटर जैसा कुछ छोड़ता है जिससे कि डस्ट पार्टिकल नीचे चला जाता है और उससे प्रोटेक्शन मिलती है। आपने ये प्रोडक्ट देखा होगा, आपने दिल्ली में या हर जगह अभी कंस्ट्रक्शन साइट्स पर ये चीजें हो रही हैं कि आप वहाँ वो प्रोडक्ट डाल रहे हो। लेकिन उस केस में जो ये पेटेंट हमने जिनके लिए हमने किया, ये उनको हमने इस डस्ट सप्रेसर के लिए उनको पेटेंट हमने दिलवाया। फिर उसके बाद उनके बिहाफ पर यहाँ अभी जब वो बिडिंग हो रही थी, गवर्नमेंट बुला रही थी कि आप ये काम करना है मुझे, तो वो वहाँ गए। तो उस केस में कुछ पार्टीज आई थी, इन्होंने कहा कि इस पर मेरा पेटेंट है, सो हाउ कुड एनीवन एल्स कैन डू दिस। So we have sent the notices, and for so long period, people are not using it. They are having the monopoly, and we are saving them from all the infringers also. So there is no possibility either your product is not getting protected, so only then you can think of that someone is uh, doing this. क्लियर है?
Yes, sir. Yes, sir.
हाँ, नहीं, अगर फिर भी जैसे आपका प्रोडक्ट सस्ता तभी कोई बेच सकता है जब वो आपसे पहले परमिशन लेगा।
एज अ
बिना-
डीलरशिप ना सर?
हाँ, आप डीलरशिप दोगे ना, आप उसको राइट दोगे ना, उसको पैसे लेंगे आप उनसे, नहीं तो आपने इतना इन्वेस्टमेंट क्यों किया? कोई चीज
सर,
आप, हाँ,
अगर कोई उसको मॉडिफाई कर देता है या उसको मतलब डिजाइन चेंज कर देता है या फिर कुछ भी ऐसे कर देता है, तो उसके बाद भी तो मतलब वैलिड रहेगा मेरा पेटेंट या फिर?
राइट, तो अभी यही मैं कर रहा हूँ कि अभी आपने पहले बोला कि वो आपका प्रोडक्ट है, उस प्रोडक्ट का डिजाइन भी हमने प्रोटेक्शन लिख कर रखा है। फिर जितने पॉसिबिलिटीज होती है ना, जैसे जब आप एक इंडस्ट्रियलिस्ट हो जाते हो, जब आप एक बिजनेसमैन हो जाते हो, तो आप अपने घर के अपने चारों तरफ से बाउंड्री करते हो, हर चीज अपना उसको सेव करते हो, करेक्ट? तो आपकी एक टीम अलग से होती है जो आपको उस पर आपको सपोर्ट कर रही होती है, और वो हर उस पॉसिबल एरियाज को लॉक कर देती है जिधर से कोई आपको इन्फ्रिंज कर सकता है। जैसे अभी आप कह रहे हो कि सर वो थोड़ा माइन्यूट चेंजेस कर दे, तो ये सारी चीजें आपको आपकी टीम सपोर्ट करती है कि सर ये संभावनाएं हैं, इन चीजों को हम लोग को प्रोटेक्ट कर लेना चाहिए। और चूंकि बाय दैट टाइम, और आपका बिजनेस चूंकि है, आप उसमें ऑलरेडी अच्छा इन्वेस्टमेंट कर चुके हो, तो आप हर उन चीजों को प्रोटेक्ट करके रखते हो जहां कोई चोरी कर सकता है, हर उस जगह पर ताला लगाते हो जहां से एंट्री की पॉसिबिलिटी होती है। और अगर वो फिर भी अगर वो कोई करता है तो आप उसको सू करते हो और उससे आप पैसे क्लेम करते हो, मिलते हैं। और ये बिल्कुल मतलब संभव बात मैं आपको बता रहा हूँ, लोग चोरी
Okay,
करते हैं। मैं आपको बताऊं, ये जो छोटे छोटे किराना दुकान जो होते हैं छोटे छोटे कहीं पर कॉलोनीज में, वहां टाटा का डुप्लीकेट माल कोई बेचता हुआ पकड़ा गया और हमें पता नहीं था, लेकिन जो टाटा के डीलर थे उनको ये बात समझ में आ गई कि मैंने इसे माल नहीं दिया, ये कैसे ये बेच रहा है। उन्होंने जैसे ही बताया अपने कंपनी को, कंपनी की जो आईपीआर टीम थी वो, उनका चूंकि वो प्रोटेक्टेड प्रोडक्ट है, तो उन्होंने शो किया, सारा माल जब्त करके ले गए, उठा करके ले गए पब्लिक को। मतलब ये कॉपीराइट एक्ट के अंदर उनका था, पूरा प्रोटेक्शन मिला हुआ, और एकदम इंस्टेंट उनका अरेस्ट होता है, सीजर इंस्टेंट होता है, कोई बहुत स्ट्रांग लॉ है, आप बच नहीं सकते हो। तो वो उठा करके ले गए और मतलब मुसीबत झेलनी पड़ी। तो मान लो 1000, 2000, 5000, 10,000 का पैसा कमाया और उनसे बहुत ज्यादा उसके बनिस्बत में उनको नुकसान हुआ। तो मैं सिर्फ इतना आपको बताना चाह रहा हूँ कि जो अभी आपके मन में है कि क्या सर हमारा इतना इन्वेस्टमेंट, मेरा इतना कुछ किया हुआ बर्बाद हो जाएगा, बर्बाद नहीं होगा, बशर्ते आप उसका आईपीआर प्रोटेक्शन ले रखें। नहीं ले रखे होंगे तो ऑब्वियसली वो तो फिर जनरल चीजें हो गई। आप बिना बताए मार्केट में नहीं जाइए कभी भी। मार्केट में जैसे अभी आप लोग प्रोटोटाइप ले जाकर के भी दिखाते हैं किसी को, आई विल सजेस्ट यू मस्ट फाइल प्रोविजनल, एटलीस्ट प्रोविजनल भी आप फाइल कर रखे होगे तो आपको टाइम मिल जाता है कि मेरा फाइल किया हुआ है। जिस दिन आप वहां रिकॉर्ड में एंट्री करवा देते हो, ग्रांट होना में मान लो 1 साल लगेगा, लेकिन आपने गवर्नमेंट को बता दिया कि सर दिस इज व्हाट माय इन्वेंशन इज, सो व्हेन द मोमेंट यू एंटर्ड देयर with the patent office, with the copyright office, with the design office, with any of the IPR offices, you entered your idea things there, then from that time onwards you can claim it to be your own, and then you get the protection. फिर आपको कोई भी नहीं कह सकता कि ये मेरा है, तो आप उसको मिल जाता है आपको प्रोटेक्शन। Anything
Okay,
else?
sir. No, sir. All clear.
Right. So this is what is called invention, and new invention. New means what? That is a new, technical question. So when we sit in front of the examiner and the controller, it is rarely that any of the inventor actually faces the controller because they don't know how to reply. So that is why almost in 99.9% cases, it is always some patent attorneys used to face the controllers to defend the patent of their clients. Like you have the products and we are representing you. So we used to face the controllers because we know what to speak and what not to speak also, right? So there they used to ask that how will you claim this to be new? So by that time, because we have already done so much of the work on those products, we understand that what exactly make it new. So when we talk about new, it means any invention or any technology which has not been anticipated in publication in any document or used in the country or elsewhere in the world. However, it looks very general for everyone other than us, right? Like means for inventor and for the patent attorney of the inventor. It is only these two people who understand, actually who claims that actually this is new, noble. Rest of the person says, इसमें नया क्या यार, ये तो पहले भी था. बट हमें पता होता है और हम ये डिफेंड कर पाते हैं सबके सामने कि इसमें नया क्या है. इन्वेंटर को भी पता होता है क्योंकि वो जानता है कि मैंने नया क्या किया है. जैसे अभी एक आप में से मैं देख नहीं रहा हूँ, आपका चेहरा दिख नहीं रहा, तो एग्जैक्टली आई एम नॉट बीन एबल टू फिगर आउट कि किन्होंने कहा. लेकिन आपने कहा कि सर क्या प्रोडक्ट कीमत मैं कम रख रहा हूँ मार्केट में, तो इससे क्या नयापन आ सकता है. अब क्या है सर, आप नुकसान में तो बिजनेस नो वन इज गोइंग टू डू, राइट? सो व्हेन यू आर गोइंग टू डू सम बिजनेस एंड फॉर लॉन्ग टर्म, इफ यू आर गोइंग टू डू द बिजनेस, you will definitely be making some money out of it. So if the price is cheap, it means you are doing something that is making it cheap. So by that way, you may you may say that there is something new, and uh, by that way we prove that actually this is a new technology, right? Anyway, so calling something new, it means there is something new inside the technology, there is something new inside the invention. The implication is lesser cost. The implied meaning is lesser cost. But lesser cost is not just for the sake of lesser cost, right? It is lesser cost because the cost of production, somewhere you have used some technology that has actually resulting into the lesser cost. So what is important is that it should be a new invention. Then next part that is important here is that inventive step. Means it should not be that कोई भी आदमी इसको कर सकता था. साहब चाय कोई भी बना सकता है, बिल्कुल सही बात है. तो ये नोबल में नोबल हो सकता है आपको पहली दफा जब पता चला तो अब नोबल आपने किया. लेकिन ये तो कोई भी दिमाग में आ सकता है कि चाय में मैंने उसमें पहले पानी डाला या फिर पहले दूध डाला, उसमें चाय पत्ती डाली गरम करके और चीनी डाला. ये तो नॉर्मल बात है. तो नॉर्मल बात है इसका मतलब इसमें इन्वेंटिव स्टेप नहीं है. It should be something that people cannot by default think while thinking about anything. So if by that means you prove, means we used to prove in that way that सर ये सब नहीं सोच सकते, हम ऐसे ऐसे कर रहे हैं. तो वो इन्वेंटिव स्टेप हम प्रूव करते हैं उनके सामने आपके प्रोडक्ट को लेकर के कि ये सब नहीं सोच सकते. तो इन्वेंटिव स्टेप का मतलब आप लोग को समझ में आया? नहीं, फिर से बोलूं?
Yes, sir. एक बार थोड़ा और explain
There's a message in the chat box.
You can put it there. Anyway, so what I'm stating here is when we are talking about inventive step, yeah, here it is. So inventive step is about steps that you do or that you undertake to develop the product. Now, if those steps are very general and common and anyone can think about it, like just I told you that making tea from its ingredients like sugar and milk and tea leaf No, it is very obvious kind of thing. So inventive step means whether the things that you are as thinking that you are applying is obvious or non-obvious. So it should be to be given means for the patent to be granted, it should be non-obvious. But for inventors, these are the things I'm just making you understand. It should not be like अब आपको ये टेंशन हो जाए यार मेरे में ये इन्वेंटिव स्टेप तो नहीं दिख रहा है, ये आपको नहीं सोचना है. आपका जो काम था वो आपने कर दिया. You all have come up with the ideas and you have developed something. Now it is not your part. The technical person who is actually expert of those domain, they will take care of these things. They will prove the controller that yes, it is having the inventive step. It is noble also. Means, but nobility cannot be proved. Nobility is something that if it is there, it is there. If it is not there, it is not there, right? So that, and in the beginning itself also, one of my friend was stating that sir, how to check the nobility. तो nobility check करने का बहुत एक अलग डोमेन है, काफी वक्त देना पड़ता है. बहुत सारे पेड डेटाबेसेस होते हैं. जो गूगल है वो एक फ्री डेटाबेस है, वहाँ सब कुछ जो फ्री में अवेलेबल है, जिसमें 20 साल हो गए, 10 साल हो गए, तो जो फ्री डेटाबेस की चीजें वहाँ होती हैं. लेकिन इसके अलावा भी बहुत सारा डेटाबेस है जिसको कि सर्च करना पड़ता है, और उसको सर्च करने के बहुत तरीके होते हैं. उसके बहुत सारे अलग उसको अलग अलग कैटेगरीज में क्लासिफिकेशन किया गया है. उसके आधार पर फिर हम लोग चेक करते हैं, और वो काफी टाइम टेकिंग प्रोसेस है. वो बहुत दिनों तक चलता है. तो बड़ी बड़ी कंपनियां व्हेन दे आर कमिंग अप विद the new ideas, they are investing lakhs and lakhs. Means one search may cost more than 20 lakhs rupees, and it may go up to 2 months, 3 months, 4 months, 6 months also to come up with an conclusion that sir, now it is not there in the market. And once people like us give this thing that it is not there in the market, it means now you can invest whatever you want to invest, because ultimately it is noble, so you will get the patent getting granted, and then you can do the business freely. So that is the way of getting this searching done.
Sir, Priyanshu has a question.
Yeah, please.
Sir, so he writes, sir, we have got a feature in our which is kind of same as compared to the Instagram's new feature. Uh, it just came in 2 weeks ago. It isn't same, but kahin na kahin similarities hai between the feature that they have in their app and the feature that Instagram has come up with. What would you suggest us on this? Should it be a concern for us or not?
अच्छा, ठीक है. ये राइट जानवी मैम, ये बात भी जो है ना, ये प्लेटफॉर्म सही नहीं है हम लोग को ये डिस्कस करने का. मतलब जो हैं इंडिविजुअल जिनका ये
Yes.
मैटर अभी हम लोग डिस्कस कर रहे हैं जानवी मैम, तो उनको हम लोग इंडिविजुअली 1-to-1 कर लेंगे, क्योंकि ये कॉमन बात है. और यहाँ मतलब जो उनका, फिर वही बात है जो मैं आपसे कह रहा था कि हम लोग जब इन्वेंशन में जाते हैं तो हम इस बात को इंश्योर करते हैं कि वो सिर्फ उनके बीच में हो और उनके बीच में हो. none other than them, right? So see, means it is possible.
I'll
Everything is
see what I
possible.
can do about that.
तो आप, ये मुमकिन है, कुछ चीजें करनी होंगी, उसको किया जा सकता है. आप में कुछ नयापन है, बस आप इतना इंश्योर करना. बाकी जो कुछ कॉमन है उसको कैसे सेफगार्ड करना है, उसको हम लोग फिगर आउट कर सकते हैं. ठीक है.
Yes.
Yeah, may I move ahead?
Yes, sir, please.
Yeah, okay. हाँ, so आप मुझे बताना, मैं उसको अकॉर्डिंगली मैं देख लूंगा उसको. अभी
Sure.
फिर तो पहला चीज ये हो गया. दूसरा चीज उसका इंडस्ट्रियल इन्वेंटिव स्टेप हो गया, और तीसरा है उसका इंडस्ट्रियल एप्लीकेशन. इंडस्ट्रियल एप्लीकेशन का सीधा मतलब है कि क्या हम मल्टीपल प्रोडक्ट्स बना सकते हैं वैसा ही जो हम लोगों ने सोचा है. उसकी डिमांड होगी तो वो इंडस्ट्रियली क्या प्रोडक्शन हो सकता है, इंडस्ट्रियल प्रोडक्शन उसका हो सकता है. तो अगर इसका जवाब हाँ में है तो हम उसको कैपेबल ऑफ इंडस्ट्रियल एप्लीकेशन मानते हैं. सो नाउ, so these three prerequisites are there for getting the grant of patents. Okay. Now, once the patent is getting granted, the patent owner may give permission to or patent or license or to other parties to use the invention on mutually agreed terms. जिसमें आप जिनको दे रहे हो वो भी agreed हैं और आप भी agreed हो तो आप दे सकते हो. ये होता है, यही होता है basically when you have the patent. It is not like every person who is having the patent is having the business. I have been working few years back. I have been with one of the university, and there the professor got some patent with very excellent idea. So they said, sir, इसको कहीं इसका commercialization कर देना है. So accordingly, we took that assignment also, and we got it commercialized. The professor got good amount, more than 50 lakhs he got for that, and then so that is your choice. However, the way you want to. However, it was, we never suggested. We said, sir, you should go ahead, because 50 लाख कुछ नहीं होते हैं. एक अच्छा इन्वेंशन होता है तो 50 लाख नहीं, वो कई करोड़, मल्टीपल करोड़ उसका वो दे सकता है, प्रोवाइडेड वो आप कितना उससे चाहते हो निकालना. Right, but it is important that a patent expires in 20 years. So you are not supposed to set. आपको फिर से कुछ आइडियाज पर काम करते रहना पड़ेगा और कुछ नई नई चीजें लाती रहनी पड़ेंगी, सो दैट कि वो 20 साल का दौर जो है वो कभी खत्म ना हो और पेटेंट ऑफ एडिशन चलता रहे और आपका बिजनेस लगातार फ्लोरिश करता रहे. राइट, सो दिस इज अबाउट द पेटेंट. नाउ दिस आर समथिंग, कहाँ कहाँ उसका एप्लीकेबिलिटी है उसकी बात है, तो इसको आपके लिए नहीं रखता हूं मैं. इट इज मोर एकेडमिक, तो इसको मैं भी आपके लिए छोड़ देता हूं. अभी मैं कुछ चीजें ऐसी भी हैं जो पेटेंटेबल नहीं है, जैसे कोई मेडिसिनल, सर्जिकल और क्यूरेटिव, डायग्नोस्टिक, थेराप्यूटिक, ये सब चीजें जो होती हैं वो नहीं होती है. However, ये एकेडमिक ज्यादा है. Means when we say that something is not getting patented, right? So जनरल टर्म्स में लॉज ने डिफाइन किए हैं ये चीजें, लेकिन it doesn't mean that by default anyone who assumes their thing to be in that, falling in that category, they should be saying कि अब तो मेरा होगा नहीं तो मैं तो नहीं बढ़ने वाला. I will always be suggesting is that whenever you come to have something new, that is, something brilliant idea, don't simply sit idle. Go and talk to some of the professional with regard to this IPR, because वो हो जाता है. Ultimately हमने when we went to almost 5-6 years back, when we went to one of the, I will not name those universities, there some students were there and they got some product which was falling under this category, and they were not being able to get the patent granted. Now the problem was that the people were not professionally trained there, and they were having some academic idea that because this falls under this, so we will not be getting it through. So, but ultimately there were 3 patents and we got all 3 for them. So yes, academically it is there in the law written that there are these categories. Under these categories, these are the things that is not getting patented. That is correct. But there are always some way out. So what is important is you just need to work upon your idea. You come up with something new, and rest let the professionals to work upon. They will get the patent, they will get the design, they will get the copyright, they will get the trademarks, and all these things are possible. There is no problem. They are good professionals, so they will take care of those things. Now you are supposed to develop the things, and you are supposed to develop your uh, business idea and then work on it. That's all. Now, who can file the patent application? So in India, the section 6 and section 134, these are two sections that actually talks about that who can file the patent. So application can be filed either uh, alone or jointly. You alone can also file it, and actually the person who is filing, it means that anyone can file. There is no age bar, there is no religion bar, there is no gender bar. So there is nothing, no bar at all. So anyone who there is there is an invention, so patent can be filed against it. Any person claiming to be, but yeah, definitely he will be claiming that he is the true inventor, and then he can file it. And by any person being the assignee of person claiming to be true or the first inventor, तो अब मान लो आपने इन्वेंट किया और आपने कहा कि आप इसके फर्स्ट इन्वेंटर हो, अब आपने किसी को असाइन किया, आपने हमें असाइन किया कि आप मेरे, यही होता है, दिस इज व्हाट इज द प्रैक्टिस। तो या आपके जो लीगल रिप्रेजेंटेटिव हैं, तो ये दोनों लोग आपके बिहाफ में पेटेंट फाइल कर सकते हैं। आप खुद भी फाइल कर सकते हैं, हाउएवर वी डू नॉट सजेस्ट, बिकॉज वहाँ जो चीजें प्रोटेक्ट करनी होती हैं यूजुअली वो बिकॉज ऑफ लैक ऑफ नॉलेज वो छूट जाता है। तो वी ऑलवेज सजेस्ट opt any of the professional, but must go with some professional while you are protecting your ideas, right? So your legal representative and the person whom you assign uh, to file these applications, they can file patent application. Now, where to file the patent application? So you, and I hope you all are aware about it. The IPR is actually territorial right. Territorial right means there is a government. So Indian government have its own territory, and we are sovereign. And all those other sovereign, there are more than almost 200 countries are there. And out of 200, almost 185 countries are having, we are all in under one law. So we have, we all agree that, okay, I will respect your, you will respect mine. Similar, in this way, we have this understanding. So in India, if we have got some patents, so if we want it in the US also, or we want wherever our business are there, so where there, if we want, we take the rights there. And once you get right in your own, there is a higher probability you get in others also. But there is a time limit also. So accordingly, in the beginning itself, people will suggest you, means the professional team that is who is supporting you in your invention protection, they will guide you that what to do and what not to do accordingly. So this is territorial right is there, that is you have to understand. Now, how this means who all can, in India itself, there are 4 offices. There are Chennai is one center, then Kolkata is another center, then Mumbai is there, and then Delhi is there. All the people from this North India, they are going to Delhi office for their filing. Means however we are filing across India, and but from here itself we are, because we know that you are from the, your address is from Chennai, so we are filing in Chennai office. When your address is there in that Kolkata region, so we are filing in Kolkata region. So accordingly we are fighting the cases in accordingly in the same way. If your infringement is happening in Kolkata region, we are taking up the cases in the Kolkata region, and similarly in Mumbai region, if someone is infringing, we are handling the cases. So from here, and it is good thing that when the corona came in, then they give us so many of the options that everything is now online and we are able to do all the things. So this territorial limits means it is important just in the sense that wherever you belong and you fall in that area, and that decides that where your application is going to be filed. Is it clear? Now, this is something you might not be able to uh, knowing, means you were not knowing earlier. So you please let me know territorial rights limits. Are you able to understand? नहीं बोलते हो इसका मतलब मुझे लगता है कि फिर से बोलना पड़ेगा. बोलूं? You all are there?
Yes, sir.
Oh my God. Thank God. So territorial right means anyone, please let me know. Means these are 4 offices: Chennai, Mumbai, New Delhi, Kolkata. This is for patent, not for design, not for copyright, not for trademark. This is for patent. So for patent, there are 4 jurisdictions. Yeah.
I guess your screen is static and we aren't able to see the current slide.
Are you able to see now?
No, sir.
No.
Yeah,
Yes,
now
sir.
it.
Now it
It's
is
clear.
working, right?
Yeah.
Okay. So there are 4 offices. Are you able to see these 4 offices? This is Chennai, Mumbai, New Delhi, Kolkata, right? Yes or no?
Yes, sir. Yes, sir.
Yes, sir. So now, if your address is, you are the applicant, you are the inventor, and your address is in Chennai region. Chennai region means your address is in Andhra, in Karnataka, in Kerala, in Tamil Nadu, in Union Territories of Pondicherry and Lakshadweep. So your application, any of the person or you yourself is filing in Chennai. It is not to be filed in Mumbai. It is need to be filed in Chennai. Then accordingly, from the people from Maharashtra, Gujarat, Madhya Pradesh, Goa, Chhattisgarh, and Union Territory of Daman and Diu and Dadar and Nagar Haveli, they go to Mumbai. Now we from Haryana, Himachal, Jammu, Kashmir, Punjab, Rajasthan, UP, Uttaranchal, Delhi, and Union Territory of Chandigarh, we all go to New Delhi, right? And the rest of India goes to Kolkata. If someone is not there in this list, they go to Kolkata. But we all, it's not like that we cannot file. Means we can do from here itself. We are getting it done across India. We are filing in Chennai also, Mumbai also, New Delhi also, Kolkata also. But it is important that it needs to be filed as per your jurisdiction. Means wherever your address is, as per your address, it needs to be filed accordingly. Correct? Is it clear? Yes, sir. तो बोलना पड़ेगा भाई.
Yes, sir.
Right. Okay.
Respond to his questions.
Yeah. Okay. So now how to file a patent application? There is a website. It is mentioned here. You can see it, ipindiaonline.gov.in. This is the website. And now from this website, this is Indian Patent Government website. And from there, they have given it that, yes, you can file it. So you can use this also to file your patent or to take any other information also. ये खुद भी जाकर के आप पेटेंट ऑफिस में अपना एप्लीकेशन सबमिट कर सकते हो और एप्लीकेशन थ्रू पोस्ट भी भेजा सकते हो. ये लेकिन एकेडमिक बातें हैं जो मैं अभी आपसे कह रहा हूँ. हम ऐसा सजेस्ट इसलिए नहीं करते हैं क्योंकि अल्टीमेटली कोई चीज जो आपने बहुत मुश्किल से क्रिएट किया है उसको इन जनरल बिना किसी प्रोफेशनल ऑब्जर्वेशन के अगर आपने कहीं पर रखा, फिर no one knows about its future. That's all. So otherwise, but yeah, law states that anyone can, like आप देखो, law states that you can go to the court and you can fight your case. There is no problem. But no one goes without any advocate. They go through their any of the advocate to fight against any of the injustice happened to them, right? So accordingly, here also, when you have some thing in your hand, you must take some professional help. That's all. But yes, laws state that if you know it, if you have the idea and you can do it, this is the link. You can copy it or you can write it down and you can do it. There is no problem. No one is going to stop you about this. It is possible. You can do. Okay. Now next. ये तो वो बात है, हम अपने लिए कुछ मार्केटिंग लगता है कर रहे हैं कि हम लोग के पास आइए. Anyway, now these are the stages. Now this is something important that you have to understand, that what are the different stages of getting the patent granted. The first stage is wherein you are actually filing the application. An application is getting filed in two ways. Like I told you, that let us suppose that you are under process and you are not exactly clear about that something may come up in days to come. So you can file it provisional. Provisional means there is still something left, right? So the incomplete invention is called provisional. So you can file it provisionally also. After filing provisionally, we used to get 1 year time, and within 1 year we have to file the complete application. So whatever is the case, we always suggest the moment you come across the idea and you are serious about doing some business out of it, don't hesitate. Simply file the provisional and go ahead with the business. You are going to show someone with your business idea, file the provisional patent. You are anything that you are willing to do in, because you are going to show someone. You don't know, means people are very people are uh, very shrewd, and they don't let you know that they what is there in their mind, and they will trick you and they will make the things out of it, and it is your idea which will get wasted. So the moment you are showing it to anyone, you please get it saved under your name. And saved means you are simply supposed to inform the government of India through patent office that it is yours one. Now the process will take time, but they are aware now that it is in your name. So we can prove it that in days to come that, sir, today I've got the grant, but see, I told you 1 year back that it was mine. So accordingly, things will be taken care of. Okay. Right. So this is the first thing that we have filed. Then it goes for publication. Publication means it comes into the public domain, wherein everyone will be informed about the invention of yours, that you have got this idea and this idea is in your name. So from the date of filing, you can start doing business. But if you want to show someone that it is, see, it is my patent thing, so that publication gives you that platform wherein you can show it to others that it is yours. Then once it is getting published, then you go for the examination. Request for examination used to be filed. Then examination issues, the examiner issues the first examination response, and we used to reply it as per their the problems that they see in the invention. They used to show us the questions as per the law, and we used to give the answers accordingly. The patent is getting granted, and then after getting the grant of the patent, if someone is against it, they can appeal. However, it rarely happens, but overall these are the stages of filing to patent of the patent, grant of the patent. Now what are the documents required? The documents are required for as covering letter, then application of grant of patent in form 1. This is mentioned in section 754 and 131. All these are academic things. Probably you people are not required to have this. But yes, third part is required. That is form 2, what we call complete or provisional specification, and then statement and undertaking in form 3. Then power of attorney, if at all you use us in your invention. Then next part is declaration of inventorship in form 5, and then certified true copy of priority document, and then requisite statutory fees. Like in patent we have 1600 for natural person, and for 2500 for one another publication. So the 4100 roughly it comes the cost for the first part till publication, that government used to charge from the applicant. So these are the documents are required. So all these, if it is available with you, you can file it. Next is the kinds of patent application that just mentioned you in the beginning itself, that if you have something complete, everything, so you go for the complete specification, and if you have incomplete, then you can go for the provisional one. Now these are the why one should go for the provisional, because there is an urgency, because you have to show in the market that you have come up with a brilliant idea. So for that you cannot wait, or you want the money, so you do not want to wait, you want to show others, so accordingly you will get the amount and then you will move ahead. So for that reason one should go for the provisional specification, because the commercial disclosure is happening there, or in case of submission of thesis and all those things also people, or sometimes accidental disclosure भी हो जाता है, तो आपको उससे बचने के लिए it is always suggested कि आप प्रोविजनल स्पेसिफिकेशन डालो, या फिर आपके बहुत सारे कॉम्पिटिटर्स हैं मार्केट में, तो कहाँ कैसे दिखाओगे इट इज योर्स. आइडिया कैन बी शोन ओनली बाय फाइलिंग सम और द अदर आईपीआर. कोई ना कोई तो सर्टिफिकेट चाहिए आपको, कहाँ कैसे पता चलेगा कि आपका है. तो उसके लिए एक प्रोविजनल स्पेसिफिकेशन भी आप अगर डालते हो तो इट इंडिकेट्स कि ये आपका है. अब आपके पास एक कागज आ जाता है जिसको आप शो कर सकते हो किसी और. करेक्ट. सो दिस इज व्हाट इज कॉल्ड प्रोविजनल स्पेसिफिकेशन. इसके कंटेंट्स होते हैं, ये सारी चीजें हैं. टाइटल ऑफ इन्वेंशन चाहिए हमें, आपका फील्ड ऑफ इन्वेंशन, ये सब हम आपको गाइड करते हैं, या कोई जो प्रोफेशनल होता है वो आपको गाइड करता है कि इसमें क्या होना चाहिए. आप एक आइडिया देते हो, उसके आधार पर फिर एज पर लॉ जो रिक्वायर्ड चीजें होती हैं कि क्लेम्स क्या होने चाहिए, एब्स्ट्रैक्ट, ये सारी चीजें क्या होनी चाहिए, वो हम एज पर लॉ हमें बनाना होता है, वो हम फिर आपको बता देते हैं ये सब चीजें. लेकिन हमें भेजनी होती हैं जब हमें वहाँ फॉर्म हम जमा करते हैं. तो इस तरह से पेटेंट इज ओवर. नाउ द सेकंड पार्ट इज डिजाइन. डिजाइन थोड़ा छोटा डोमेन है in spite of in comparison to patent. Now design is about only the look, what is in front of you. It is not in what is inside the product. See, when we talk about the product, you know, in product there is a lot of thing inside. You talk about any of the product, there are a lot of things inside. There is a process, there are multiple machines working in different ways, the process is happening, right? So that is what is called product. The process is there. But in industrial design, how it appears. So for a product to function in a certain way, there should be some restricted design also. It cannot be like any of the design will work. No. For certain products, the designs also used to be very peculiar, very specific, and the way it is getting represented, means the way it is shown to others, it is an ornamental aspect. वो खूबसूरत कितना दिखता है वो आप डिसाइड करते हो उसके थ्रू. उसको आप एड़ा टेढ़ा कुछ भी बना देते हो तो दैट डजंट मेक एनी सेंस. तो वो इंडस्ट्रियल डिजाइन की कैटेगरी में आता है. तो ये 3 डायमेंशनल फीचर भी हो सकता है, और ये शेप ऑफ द आर्टिकल हो सकता है, ये 2 डायमेंशनल भी हो सकता है, जैसे कि पैटर्न्स, लाइंस और कलर्स, ये सारी चीजें भी इंडस्ट्रियल डिजाइन के अंदर में कवर होती हैं. ओनर ऑफ द रजिस्टर्ड इंडस्ट्रियल डिजाइन or of a design patent has the right to prevent third parties from making, selling or importing articles bearing or embodying a design which is a copy of protected design. वो हर वो चीज जो आपने प्रोटेक्शन ले ली है, उसी तरह से जैसे आपने पेटेंट में आपको एक्सक्लूसिव राइट मिलता है, उसी तरह से आपको इंडस्ट्रियल डिजाइन के कैटेगरी में भी आपको यू गेट द एक्सक्लूसिव राइट एंड नो वन एल्स कैन कॉपी इट, राइट. और क्लियर अबाउट डिजाइन, कोई प्रॉब्लम डिजाइन के केस में जो अभी आप और बात कर रहा हूँ मैं, आपको प्रॉब्लम हो तो इन बिटवीन यू फील फ्री दैट आप बीच में रोक सकते हो, कोई दिक्कत नहीं है उस मामले में. फिलहाल काइंड ऑफ प्रोडक्ट्स फॉर इंडस्ट्रियल डिजाइन प्रोडक्शन, जैसे कि हम प्रोडक्ट्स ऑफ इंडस्ट्री आइटम्स. लेकिन क्या इंपॉर्टेंट है, आप कोई भी डिजाइन बनाते हो लेकिन क्या वो फिर से बन सकता है, क्या उसका इंडस्ट्रियल प्रोडक्शन हो सकता है, ये इंपॉर्टेंट एस्पेक्ट है अगर हमें इंडस्ट्रियल डिजाइन का प्रोटेक्शन लेना होता है. मींस आपने कोई एक चीज बना दी और वो दोबारा नहीं बन पा रही है, नहीं बन सकती है, तो हम उसका वो प्रोटेक्शन नहीं ले सकते, हमें वो नहीं मिल सकता. क्यों? क्योंकि उसकी इंडस्ट्रियल एप्लीकेबिलिटी नहीं है. तो इंडस्ट्रियल डिजाइन कहलाने के लिए इट इज इम्पोर्टेंट कि उसका फिर दूसरा कॉपी बन सकता है और उसके कई कॉपीज बन सकते हैं. ये इंपॉर्टेंट पार्ट है. क्या क्या हो सकता है, तो वो इंडस्ट्रियल आइटम्स हो सकता है, हैंडीक्राफ्ट आइटम्स होता है, हाउस होल्ड गुड्स हो सकता है, लाइटिंग इक्विपमेंट हो सकता है, ज्वेलरी हो सकता है, इलेक्ट्रॉनिक डिवाइसेस हो सकते हैं, टेक्सटाइल्स हो सकती हैं। ये सब के केस में इंडस्ट्रियल डिजाइन प्रोटेक्शन अवेलेबल है। What we mean to say is this, that when we are talking about the textiles, when we are talking about electronic devices, jewelry, lighting equipments, household goods, ये सारे के केस में it is that what we can get is the design protection. Now relevant priority ये आपके लिए नहीं है, ये इंडिया में फाइल करना हो और इंडिया के बाहर फाइल करना हो, ये उसके लिए है, कितने दिनों में आप फाइल कर सकते हैं, ये बात है। फिर पेटेंट डेटाबेस एंड right. So right now we had been talking about these two things that we have covered. Now this is done. So please let me know if anyone has any of the queries.
Hello.
Yeah, I'm there. Please let me know.
Sir, I have a query.
Yeah, बताओ.
So like हमारा ऑर्गेनिक फर्टिलाइजर्स को लेके बिजनेस है, ओके?
हम्म,
सो लाइक ऑर्गेनिक फर्टिलाइजर्स मतलब लोग अलग अलग तरीके से बनाते हैं, और लाइक हमारा हमारा तरीका अलग है उसको बनाने का, एंड उसमें इंग्रेडिएंट्स अलग हैं जिससे बनाते हैं। सो लाइक हमें हमें प्रोसेस का पेटेंट लेना चाहिए या उस प्रोडक्ट का?
इस केस में तो जो मैंने किया है, आपका जो डोमेन आपने बताया है, आई हैव गॉट पेटेंट डन इन योर डोमेन आल्सो। तो ये प्रोसेस का भी होगा, वो मैं इन्वेंशन देख करके आपको बता दूंगा कि कहाँ कहाँ पॉसिबिलिटी है। जैसा मैंने आपको पहले कहा, अभी चर्चा भी जब हम कर रहे थे, तो आप जब बिजनेस शुरू करते हो कोई अपने आइडिया पर, तो जितने भी वायबल ऑप्शंस होते हैं उन सारी चीजों को हम प्रोटेक्ट करते हैं, सारे दरवाजे हम बंद करते हैं जहां से कोई हमें कॉपी कर सकता है, कोई हमारा कुछ चोरी हो सकता है उस चीज को। तो अभी जैसे प्रोसेस आपका है अगर वहां, तो प्रोसेस को हम प्रोटेक्ट करेंगे। अगर वो अलग से प्रोडक्ट में भी दिख रहा है कुछ ऐसा चीज जहाँ की कोई और हमारा ले सकता है, तो हम प्रोडक्ट में भी करते हैं, लेकिन करना जरूरी है आपके केस में।
ओके सर।
आप मुझे बताइएगा। आई होप यू हैव माय नंबर एवरीवन। जानवी मैम, मुझे मैं शेयर माय नंबर, मैं बता सकता हूँ।
No, sir, you cannot share your number with the
चलो,
students.
वैसे मैंने वैसे लिख रखा था, मैं वैसा रहता तो ठीक है। आप लोग देख लो, आप नहीं होता तो जानवी मैम को बता देना। जानवी मैम, if at all
You can
she
reach
is,
out to me with all your queries. I'll
हाँ, वो आप लोग को बता देना, वो मुझे बता
ओके सर।
देना। और कोई क्वेश्चन तो पूछो आप।
सर शिवांश साइड, अगर जैसे हमारे पास इंडिया में फॉर इंस्टेंस हमारे को पेटेंट मिल गया फॉर आवर प्रोडक्ट, एंड हमें फर्स्ट ये भी श्योर करना है कि ग्लोबली उसकी प्रेजेंस क्या है, सेम पर्टिकुलर प्रोडक्ट इन सेम कैटेगरी, तो उसको भी वी गो थ्रू दी एक्सपर्ट्स या फिर हम किसी तरीके से देख सकते हैं उसे?
नहीं, आप देख सकते हो, इसमें कोई डाउट नहीं है, लेकिन आपको कितना दिखेगा ये बात अलग होती है। कितना दिखेगा मतलब, आप यू आर नॉट द एक्सपर्ट ऑफ दैट डोमेन, राइट? सो यू माइट नॉट बी एबल टू फाइंड आउट। लेकिन अगर आपको यहाँ पेटेंट मिल रहा है, इसका मतलब वो कहीं नहीं है तब मिल रहा है।
नो, इंडिया में तो नहीं है, बट ग्लोबल अगर चेक करना
नहीं,
हो तो?
अगर इंडिया में नहीं है, इट मीन्स अगर आपको पेटेंट मिल रहा है और आप जो कह रहे हो कि इंडिया में नहीं है, तो वो आपका एक अवेयरनेस लेवल है। आप किसी चीज को जानते हो जितना, उतना आप सोच लेते हो कि इतना, तो उसके अकॉर्डिंगली यू डिसाइड कि ये यहाँ नहीं है। बट अल्टीमेटली अगर आप प्रोफेशनली जाते हो और आपको पेटेंट मिलता है इन इंडिया ऑल्सो, तो इसका मतलब वो वर्ल्ड में नहीं है कहीं। अगर वो इंडिया में मिलता है मतलब वर्ल्ड में नहीं है। अब वर्ल्ड में नहीं है तो फिर उसके बाद आपका बिजनेस का जहाँ स्कोप है, आप वहां के लिए अप्लाई करोगे, वहां फाइल करोगे।
ओके ओके, गॉट इट।
है?
एंड ऑल्सो सर, इसमें लाइक हमें देखना होगा सिमिलर पेटेंट किसी ने करा रखा हो तो ग्लोबली, वो कैसे देख सकते हैं?
जैसे कैसे देख सकते हैं क्या, जैसे मैंने आपको पहले बताया कि एक तो गूगल सर्च है, गूगल सर्च पर कैसे, टू बी वेरी स्पेसिफिक अगर आप जाते हैं तो वो एक अलग सब्जेक्ट है। कैसे का मतलब कम से कम उसमें 4-5 महीने लगेंगे अगर मैं उसको क्लास लूंगा आपको तो, वो अलग सिखाना होता है। बट कैसे मतलब इन जनरल अगर आप गूगल पर देखते हैं, जैसे आप गूगल में बाकी कोई भी चीज खोजते हैं, अगर आपको दिखता है तो ठीक है, नहीं दिखता है तो फिर आप उसमें बढ़ना चाहिए आपको, क्योंकि वो आपका नोबल आइडिया है। और फिर किसी एक्सपर्ट को अपने साथ रखें आप, तो आपको उसका दिलवा देता है। बस नोबिलिटी होनी चाहिए, दैट्स ऑल। और नोबिलिटी चेक करने की चीज जो आप जिस तरीके से सोच रहे हो वो काफी मतलब टाइम टेकिंग प्रोसेस है। कई लोग उसमें मिल करके उसके स्ट्रिंग्स बनाते हैं, स्ट्रिंग्स बना करके हर स्ट्रिंग्स पर सर्च करते हैं, फिर वो उसका रिपोर्ट निकालते हैं, और फिर वो मैथमेटिकल एनालिसिस होती है उसके कि क्या पॉसिबिलिटी है कि ऐसा कोई चीज होगा, फिर उसके आधार पर एक कंक्लूजन होता है। ये इंडस्ट्री जो बड़ी बड़ी होती हैं, चूंकि वो बहुत पैसे इन्वेस्ट होते हैं, मान लो मेडिसिन एक नया ला रहे हैं वो, तो प्रोडक्शन करने से पहले वो डिसीजन मेकिंग से पहले वो अलग रिसर्च टीम को देते हैं, और वो एक रिसर्च टीम उस पर काम करती है 6 महीने 8 महीने, फिर वो कोई कंक्लूजन निकाल कर देती है। वो इन इटसेल्फ में बहुत बड़ा सवाल है। एज ए जनरल आप अगर आप ऐसे पूछते हैं तो आप गूगल में देख सकते हैं। इसके अलावा बहुत सारी चीजें होती हैं जो गट फीलिंग पर भी काम करती हैं, जहाँ की आपको नोबिलिटी पता चलता है कि ये है नहीं, और वो नहीं होता है। फिर थोड़ा बहुत आपको आपकी टीम भी आपको गाइड कर देती है कि ठीक है, इसको आप कैसे कर सकते हैं कि आपको इसको पेटेंट ग्रांट मिल जाएगा, या बाकी कोई भी आईपीआर का सेगमेंट में आपको मिल जाएगा।
गॉट इट सर। सर ऑल्सो एक चीज़ और पूछनी थी, लाइक फॉर इंस्टेंस अगर कंपनी है जिनके पास एक पेटेंट है फॉर अ टेक्निक जो उनके प्रोडक्ट में यूज हो रही है, एंड आई वांट टू यूज दिस सिमिलर टेक्निक इन माय प्रोडक्ट ऑल्सो, लाइक इट्स अ फीचर कह सकते हो या एक टेक्निक कह सकते हो, तो उसको यूज करने के लिए मैं मतलब अगर उनसे मुझे एज ए कोलैबोरेशन में नहीं करना, सो मैं कैसे यूज कर सकता हूँ?
अगर उनका वो टेक्निक प्रोटेक्टेड है अंडर आईपीआर का किसी भी सेक्शन में, तो हमको उनसे परमिशन लिए बिना तो नहीं करना चाहिए हमें, क्योंकि वो फिर हमको सू करेंगे हमें, और जब भी उनको पता चलेगा तो। लेकिन अभी ये आप कैसे मानते हो या जानते हो कि वो उनके पास है, वो ये उनका है? हाउ डू यू नो दिस?
सर थोड़ी सी रिसर्च करी थी, तो उनकी जो लाइक दे ओनली पोस्टेड कि वो उनकी पेटेंटेड टेक्नोलॉजी है।
अच्छा, वो पेटेंटेड टेक्नोलॉजी अगर कोई है तो सर वो पूछना ही पड़ेगा, देयर इज नो अदर वे आउट।
एंड अगर उनकी जैसे टेक्नोलॉजी मतलब लाइक जो टेक्नोलॉजी उसको हम डेवलप करें
नहीं,
एंड
आप जो
उसमें हम
डेवलप कर
अपनी
रहे हो सर,
मॉडिफिकेशन से करें,
हाँ बिल्कुल, तो आप करो ना, क्या दिक्कत है?
ओके देन वी कैन डू।
हाँ बिल्कुल, मैं तो यही कह रहा
ओके,
हूँ। आप सर देखो क्या
ऑलराइट।
होता है, किसी भी इन्वेंटर को काम सिर्फ एक ही काम है उनका सोचने का, उनका काम है अपने प्रोडक्ट के बारे में सोचना, राइट? वो अपने प्रोडक्ट के बारे में सोचें और उसको एक्सपेंड कैसे करेंगे, वो अपने बिजनेस के बारे में सोचें। बाकी चीजों के लिए अलग अलग प्रोफेशनल्स हैं, उनको आप रखो, वो ये सब चीजों से आपको निकाल देंगे। वो आपको पहले बता देंगे उस केस में कि सर यहाँ नहीं जाना है या यहाँ जाना है। वो एज एन इंडिविजुअल नहीं हम जान पाते हैं, मैं भी ऐसे बोल नहीं सकता जब तक कि मैं उस पर होमवर्क नहीं करूँ। फिर जब मेरे को होमवर्क करने के बाद कुछ आइडिया लगेगा तो मैं आपको सजेस्ट करूंगा ये होना चाहिए और ये नहीं होना चाहिए। तो ये बात है, मतलब ये ब्लैक एंड व्हाइट चीज नहीं है कि कोई चीज है
गॉट
या
इट
नहीं
सर,
है। वो उसके लिए एक अलग,
गॉट इट।
मतलब मैं अगर जानता भी हूं तो मुझे होमवर्क करना पड़ेगा। आपको लग रहा है वो कह रहे हैं तो होगा ही, मैं ये नहीं मानता। मैं तो इसको नकारूंगा कि नहीं, मेरे क्लाइंट को ये जरूरत है और इनकी जरूरत के अकॉर्डिंगली मैं सोचूंगा। तो मैं तो कहूंगा कि नहीं सर आपका नहीं है, आप दिखाओ पहले, तो मैं उनका देखूंगा, उसके देखने के बाद फिर मैं आपसे बात करूंगा कि हमें क्या चाहिए, उसके अकॉर्डिंगली हम उन चीजें को, मतलब फिर वो, मतलब वो एक अलग बात है। तो आप अपने काम पर फोकस करो और आप आगे बढ़ो, और सब मुमकिन है कि आपकी चीज आप जो चाहते हो आपको मिल जाएगी। अगर ऐसा कुछ होगा जो उनसे लेना होगा तो भी आप बात कर सकते हो, एवरीथिंग इज पॉसिबल।
गॉट इट सर, थैंक यू सर।
हाँ, don't stop anywhere because you got some thinking in your mind. Don't stop, just do it. मतलब आप जैसे लोग की बहुत जरूरत है इंडिया को, और मतलब आप जैसे लोग बहुत इंडिया को देंगे। आप लोग अगर 20 प्रोडक्ट लाते हो, आप नहीं समझते हो कि भारत को उससे कितना मिलता है। हाँ, कितने लोग उससे फायदे में होते हैं। आपका प्रोडक्ट जब बाहर जाता है तो जो पैसे आते हैं वो आपको ही सिर्फ नहीं मिलते हैं, वो देश की इकोनॉमी को भी बूस्ट करता है। तो आप लोग स्टॉप नहीं करो। You people must do whatever you are thinking without thinking about any of the hurdle, because for all the hurdles, like अभी आप नेस्कॉम के साथ हो, हमारे साथ हो, तो हम जैसे लोग आपको मतलब we are going to help you in any of your travels. There is no problem. You just keep moving ahead. ये बैटरी लगा लो इसका। Right. Any other question? आवाज आ रही है? All good?
Yes, sir.
All right. जानवी, आप हैं?
Hello.
Yeah, Janvi ma'am, are you there?
Yeah.
Yeah, right. So the questions are there. If at all, if it is there, please let me know.
No, there's no other question in the chat box.
Right. So can we bind up?
Yeah, sure.
Right. So all of you, good luck. You must take care of your IPR things, and then let me know in case of any trouble through your team, and then hopefully we will take care of your problems also.
Yes.
Thank you so much,
Thank
sir.
you so much, sir, for joining us. I
Thank you.
hope that I'll get in touch with you again. Thank you, sir.
Yeah. Thank you, Janvi. Thank you. You were just best because you have been coordinating quite properly. Thank you.
Thank you so much.